stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome to Administrative Static. I'm John Vecchione. I'm here with Mark Chenoweth. And we start the program today with a man who's no stranger to the news, Elon Musk. And the reason is that he is trying to get out of what he calls a government-imposed muzzle by the Securities and Exchange Commission. And as we have said on this program many times, we've talked about it, the SEC, almost alone amongst agencies, requires when you settle with them that you pledge in blood that you will never speak of this case again or say that the SEC was wrong in any way about it. You will never disclaim that you were, what happened. You can't write a book about it. This is a huge muzzling of speech, because oftentimes you have a disagreement with the SEC about the nature of it, but you want to get it behind you and you'd rather pay a few bucks and then go along your merry way, but then you can never talk about it again. And no other agency, except I think commodities futures trading, but other than that, no one does this. And the SEC does it. And because there's a legal principle that it's an agreement, once you enter a settlement agreement, it's like a contract, so it can be enforced. So it has been very difficult to get out of these. And this case is particularly interesting because a private company, a private organization representing shareholders, brought a suit against Elon, saying that his tweets that he had financing for one of his companies was false. And Elon took the stand, and the jury didn't believe that it was false. They believed that he believed it was true. And even though the judge had already found that the statement was false, he didn't have the mens rea that he thought it was false, is how I think the case fell out. So he's saying that, look, I just got out of a jury trial on this, and they're costing me all this money because every time I tweet, I have to get it run by the Tesla people. I had to leave the board, the chairmanship of Tesla. I have to have all my tweets passed through Tesla lawyers. And then you subpoena me every time I tweet. So apparently the SEC is subpoenaing him about what he meant about this, that, and the other thing in his tweets. And you can see how this would chill. He says it chills his speech. Mark, I'm not so sure it chills Elon's speech. I'm not sure that's a provable fact. For reasons that I've read his tweets.
It certainly hassles his speech.
Yes, correct. And the fact is that we've looked at this quite a bit, and even years later, 10, 50, they say, oh, well, you have to go back to the same judge and you have to ask for modification. And they say, no, you agreed to it. That's part of it. So Elon has a lot of heavy hitters. The lower court has ruled against him, but he's before the Second Circuit now. And as we have, our colleague Peggy Little has gotten some pretty good language out of the Fifth Circuit, but they also allowed these gags to stand, saying that they're terrible. But because of this principle and that principle, some that I've mentioned, nothing can be done about it. And it is in his case, he's got a little bit of a problem, I think, Mark, in that the original deal was 2018, and then he reaffirmed it in 2019 after they looked into something about Tesla. So he agreed twice pretty recently, as law goes. 3-4 years ago, it seems like a long time, but in law, So the claim is that this inhibits and chills Mr. Musk's lawful speech. And I think it does. And I think it's intended to. And unfortunately, the courts keep saying that's okay. There has to be some way, Mark, to say that the government isn't allowed to do this as part of its powers, as no part of the government's powers is to muzzle the speech of Americans. But the principle is that in this area, the government's allowed to make contracts the same as everybody else. But, Mark, I think this is a little bit like going around. It's a little bit like how they go around in social media, getting social media to do what they can't do. So they have this separate claim against somebody that they did something wrong with the securities laws, and then they're shutting them up about whatever the SEC does to them in the meantime. It really is kind of outrageous.
I agree with you, John. It's outrageous. The other thing that's interesting to me about this, I don't know if you saw, the National Labor Relations Board came out with a ruling this week where they said in the context of some kind of labor agreement that it was sort of per se unlawful to even offer an agreement that would have this kind of a gag in it in the labor negotiation.
That's right. They said that
for severance agreements, I think, or
severance. You cannot give a severance agreement that relies on the agreement that you don't say anything bad about the company. And this is normally what happens. In two ways. You have a dispute with your company. They decide to part ways with you, but they want to give you some money so you can go get another job and not be too stressed. But they don't want you running them down, so they put that in all the time. Sometimes it's mutual because maybe the employee did something that is alleged to have been bad, and they don't want a disparagement on their side either. So when I saw that, Mark, I was thinking, well, wait a minute. Both sides could be disparaging each other. They're the Labor Relations Board. They should stop friction. The whole point you have a Federal Labor Relations Board is to stop friction, and these agreements stop friction. So I thought that was somewhat anti-labor in some ways.
Well, it's certainly hypocritical for one government agency to say that for private parties, this is prohibited conduct.
Yep.
And then for another government agency to say, well, for the government, this is perfectly allowed.
It's required. It's required. At the SEC. It's not even allowed. It's required.
Well, and if this were the other thing, John, is in the SEC context, you're talking about the government being one of the parties. So it's a coercive. I mean, if anything, that's a more coercive environment than it is when you have labor and employees negotiating.
Yeah, that's true. And the other thing about it is the SEC has enormous powers for anyone who's in business. And so, it is extremely coercive. But the other thing is, it would be one thing if the SEC wasn't allowed to disparage you, but they put out their press releases.
Yeah, that's right.
We got this, and it says, you neither affirmed nor denied, but we got all this money from. I mean, it's ridiculous because it's not even like the labor context I just described, where both sides would rather get it over with and shut up about it for the rest of their lives. This is the SEC does it, puts it up on its website forever.
Very one-sided.
Very one-sided. So I think that that it would be nice if, we do know he's represented by Quinn Emanuel, Urquhart Sullivan,
and competent counsel,
and
to say the least.
Hopefully they will find a way around some of these problems we've mentioned. Because I do think, in the Second Circuit, another judge who is the daughter of, help me, Mark.
Floyd Abrams.
Floyd Abrams, right? Has written.
It's Ronnie. Is it Ronnie Abrams?
Yeah, that's it. Ronnie Abrams. Very good. And she has just had a scathing. She's in the Second Circuit. She's a district court judge there. She has a scathing opinion about how bad this stuff is, but then she says at the end, but there's nothing I can do about it because they all agreed. So in some way, manner, or form, this thing has to be addressed without an agreement. And, or someone has to say that's not really agreement, that it's coercion. There's a whole slew of cases that certain things are coercive and against public policy, and you can enter a contract that's against public policy. Maybe that's the way to go, that the contract's against public policy because we have a First Amendment. But here in this case, it's not just that his speech is being infringed. He's getting subpoena after subpoena.
Well, and suffice it to say that the single person who any owner of Tesla stock is the most interested in hearing from is Elon Musk. So the fact that
the short
his
sellers
speech,
and the investors, all everybody, right?
that's right. So the fact that his speech is being hassled on this topic is a problem.
And you know what? That's an interesting point, Mark, because in free speech cases, the speech of the speaker isn't the only thing. The listener has a right to it. And perhaps that's the way to go. Maybe we get Elon into a book agreement, and then we have Brown, little Barnes,
or
Brown,
maybe,
little.
Maybe we buy a little bit of Tesla stock and then assert our rights as shareholders to hear what he has to say.
That's good. That's good. Something along those nature, that nature, because we haven't agreed to it, by gum, and won't. And so
Damn Skippy.
So compliance with this litany of subpoenas has been burdensome, and no end appears in sight, is what he's saying. And that is exactly right. Because that's the whole point of it. They don't want there to be an end in sight. They want it forever. You made it.
No, they've got their hooks in him now. They've got their hooks in him now. They're not going to turn loose.
That's right. And it is an appalling situation. And I think the fact that he's the richest man in the world, well, I don't know about today. The market had a big hit, but he's always up there. He's not hurting for wealth and power, and that this can be constraining him and causing him all of this trouble and expense to such an extent that he's willing to go fight it, is really, I think that sharpens the point of how bad it is for regular people caught up with the SEC, because they're not going to have this ability to go complain about it and tell everybody it's undone. Anyway, let's hope he wins, and we'll be back in the while.
Welcome back to Administrative Static. Mark Chenoweth and John Vecchione with you as always. And John, I wanted to take a minute to talk about proxy advisory firms and the Securities and Exchange Commission. And people might think that this doesn't apply to them. And I assure you, if you own stock, it does. And the SEC is in the process of putting out a rule on proxy advisory firms. And I believe that there are going to be some state attorneys general suing over that. I believe they may have by the time this show goes to air, I believe that lawsuit will have already been filed. And we may talk about that next week or in the upcoming weeks. But I thought before we did that, John, it might make sense just to sort of acquaint our audience with the topic more generally, because you really need to know what's going on here in order to have an ability to understand the rule. And what this boils down to is, if you are a shareholder, then periodically there will be votes that are put in front of the shareholders on various sorts of corporate policies. And those policies can vary widely. It could be something on the CEO's pay, or it could be something about the composition of the board of directors, or it could be something about climate change. There are lots of kinds of issues that come before boards of directors, and sometimes the companies come up with these topics themselves and put them in front of the shareholders, and that's fine. Sometimes the shareholders try to force votes on issues that the company may or may not be interested in having shareholders vote on. And those become battles. They can be contentious, and sometimes they wind up in federal court. But setting that to one side, let's just assume that you have an issue that's come before the board, it's either been proposed by the board or it's been put forward by shareholders, and it's a vote that's going to be on the ballot. Well, the way that these votes work is that the person who controls the shares is making the vote. Well, if you are an individual stockholder of, and John, I'm just going to stick with Tesla since we were talking about Tesla in the last segment. If you are an individual stockholder of Tesla and one of these issues comes up, well, then you can vote depending on the number of shares you have. That's the number of votes you have. If you have 1,000 shares, then you get 1,000 votes that you can cast for or against the issue that's on the ballot, and that works just fine. But suppose, John, that you don't directly own the shares of Tesla. Suppose that you own, I'm going to make this up, but suppose that you own a mutual fund that invests in electric car companies. And so what you own are shares in the mutual fund. You don't own individual shares. And perhaps that mutual fund is invested in Tesla. It would be odd if it weren't. But it's also invested in several other companies. But again, you don't actually own the shares yourself. But the fund is a kind of fiduciary for you, and it has certain duties to you as its customer. And one of those duties is that there's a question about whether it has to vote the shares at all. You could imagine a situation where the shares were just left unvoted unless instructions were given by the shareholder. But what often happens in these situations is that the Vanguard or Fidelity or whoever it is who has issued these sort of mutual fund or other kinds of ownership arrangements, they will vote the shares. And then the question is, well, how can they be assured that the vote that they're casting, either for or against the particular shareholder proposal, how can they be assured that they are doing that in fulfillment of their fiduciary duty to you? Well, that's where the SEC came in a while ago, more than a decade ago now, maybe about 15 years ago, but don't hold me to that. And they put out sort of not a rule, but just some guidance suggesting that if companies that were in this situation relied on the advice of proxy advisory firms, then they would be fulfilling their fiduciary duty. And there are two predominant, and when I say predominant, they control over 95% of the market for proxy advisory services. One of them is called Institutional Shareholder Services. The other one is called Glass Lewis. And between these two firms, they, as I say, dominate the market. It's really a duopoly. There's very, very little other competition here, although I know Vivek Ramaswamy is trying to create another one. I'm not sure whether his presidential ambitions will cause that to sink into the background or not. But for now, there are two that dominate the market. And so what has happened over time, John, is that these proxy advisory services firms have been captured by some of the folks who have a particular agenda on climate change and other kinds of topics. So that what you see is the proxy advisory services firms routinely recommend voting a certain way on these kinds of social issue things that come before the shareholders at different companies. And if you are someone who invests in one of these funds and you don't agree with that position, you're sort of out of luck the way that the SEC has structured it now, because they have essentially insulated the company that owes a fiduciary duty to you has been insulated by the SEC from having to do what you want it to do, because it said you don't have to listen to the person who's buying your shares of your mutual fund, for example. As long as you listen to the to the proxy advisory firms, then you're good as far as the SEC goes. Well, I think you can see the problem here. This is yet another example where there's separation between ownership and control, and the people who ought to have a say in what's going on in the company are being shunted to the side. That is, the folks who I would think of as the real owners in interest, the people who are actually bringing money to the table to invest in these companies, are being shunted to the side. These proxy advisory firms are the ones that are being given the power, and they are using that power to drive an agenda that may not be consistent with what you as a shareholder want. Well, you would think that the solution to this would be to pull back the guidance that the agency had issued, suggesting that following what the proxy advisory firms suggest is all you have to do. But that's not what the SEC is doing, John. What the SEC is doing is they're working on a rule to sort of more or less make permanent the kind of situation that exists right now. So we'll talk about that in greater detail down the road. But as someone who, you and I were talking before the show, John, as someone who wasn't previously completely familiar with this, does that make sense? Is there a piece of this that?
Yeah,
that,
I had no idea.
About?
I obviously get proxy questions all the time from individual stocks, but I did not know how mutual funds did it, and I wondered why, how they were able to use, follow this agenda or that agenda. I assure you that if they were recommending that, the best thing to do was always vote for the fossil fuel investment for the mutual funds, that the SEC would be moving in a different direction. I have a feeling.
Right. Yeah. Suppose that were the way that it were going, or suppose that they were always suggesting that the board of directors act in order to increase the profit of shareholders and not pay attention to other stakeholder interests. I think that would also not go over with today's SEC, even though under traditional understandings of how corporations work, profit from increasing the profit of the shareholder is supposed to be what the company is doing, and not so much paying attention to these other so-called stakeholders. But you see what happens when you allow. Well, and I guess what I was going to say, John, back to your point, I get these sometimes. These things sometimes too. Do you vote them when they come to you, or do you just let them?
I sometimes do, but often, since I don't know, I merely am I don't vote yes or no. I just vote present.
Yeah.
I will say this: I always vote for the accounting firm to audit the whole thing. To
take a closer look at something.
Whenever they ask, should an audit firm look at this? I always check yes.
Check yes on that. Well, and the thing that I usually do, so sometimes when you get these things, it'll indicate whether it's been recommended by the board of directors or not. And my most common response is to ignore it and not cast my vote. My second most common response is to just see what the board of directors is suggesting and go along with what the board of directors wants, because I figure they're the ones in the best position to manage the corporation. I really am not a big believer in outsiders coming in. If you're an outsider and you want to change the way the company is managed, then buy the company. I don't believe in this sort of efforts from people who don't own very many shares of stock. They just bought a few shares, and now they're trying to force a change on the way that the company behaves. So you have famously the board of directors of Exxon was infiltrated with some anti-oil people after a shareholder vote. Well, that's absurd. If you want to invest in a company that doesn't drill oil, there are thousands of those companies out there. Exxon is not one of them. So don't vote on that one, or don't buy that one, or at least you should have to own a majority of it if you're going to change the way that the company's doing business. You shouldn't be able to force these things through this sort of backhanded way of taking control over shareholder votes through the proxy advisory firms like ISS and Glass Lewis. And maybe we'll just leave it for there, John, and we'll talk more about the specific rule on another occasion.